Hi, I'm Chris Bradley, a law professor at the University of Kentucky, and I'm here to talk a bit about a paper called Privacy Policy Indeterminacy. I'm happy to have this chance to share the paper, and I'm grateful for the support of the Law and Economics Center and James Cooper and the other participants in the Privacy Policy Roundtable this year for their excellent comments. I'm also grateful to the many research assistants who helped me out with this project, especially Justin Potter, University of Kentucky class of 2023. So this paper emerged from a body of data that I gathered from the dockets of bankruptcy cases in which courts retained an expert called a consumer privacy ombudsman to assess the legality of a proposed sale of consumer data from the debtor in bankruptcy to some new buyer. This emerges from a special provision of bankruptcy law that requires special consideration of sales of private consumer data to make sure that the sales are lawful. Interestingly, sales are often permitted as lawful, even if they are contrary to an existing privacy policy. But the interpretation of the privacy policy is often a relevant factor in determining the lawfulness of the transaction. So I collected about 140 reports filed by ombudsmen. And I've written a couple of other papers assessing this system as a matter of policy. Those papers are called Privacy for Sale, which is in the Yale Journal on Regulation, and Privacy Theater in the Bankruptcy Courts, which is in the Hastings Law Journal. This paper is a bit different. As I worked through all the reports, I noticed that many of them had made observations about the actual interpretation of the privacy policies at issue. Observations that I didn't necessarily always agree with. So together with a research assistant, I began to engage in a more systemic data gathering regarding the interpretations offered by ombudsmen. And the truth is, a lot of them contradicted either what other ombudsmen determined when faced with similar provisions, or with what we thought, as ourselves reasonably educated consumers, that a particular clause should mean. This finding is consistent with various other studies that have been done in experimental settings about the ambiguities of the interpretation of privacy policies. But what is unique about this project is that we draw data from actual cases. Now, the point of the paper is not at all to criticize ombuds. Actually, as my other paper showed, they are legitimate experts and they are neutral and independent. The point I want to make is about how very difficult it is to interpret privacy policies reliably, even when you are a neutral, independent, court-appointed expert. If it's hard for them, how much harder it is for the rest of us. And it's actually even worse than that, because as other researchers have shown, these days, privacy policies are most often interpreted by officers and employees within companies who are tasked with determining whether a proposed course of action would violate the policies. These people are, of course, not neutral or independent. And even if they're acting in good faith, they suffer from structural pressures that make it unlikely that they will provide neutral interpretations constraining their employers unless absolutely necessary. So that's the problem in a nutshell. We show that privacy policies are hard to interpret in significant respects, even by neutral experts. And since we know that privacy policies are usually interpreted by non-neutral folks, that suggests there's a real dearth of constraint. So the latter part of the paper proposes two general ways in which more constraints could be offered. First, it notes that standardization might be one option. A feeling that you have when you read a lot of privacy policies is that they really resemble each other. So you could imagine a world in which privacy policies are summarized through standard terms with meanings that are well understood and standard across the industry. You could even conduct empirical research regarding how consumers actually understand various statements and develop the passage based on that. This proposal is similar to many that have been made to have a sort of nutritional label approach to privacy policies. And I draw on that research in the paper. Conceivably, too, as others have pointed out, policies could be machine readable, which would also have a lot of benefits in potentially providing consumer control, as well as regulatory transparency into policies, again, across a large number of companies. While political will has been lacking to actually enact these approaches, and that political will, again, could be legislative or it could be based on industry efforts. These possibilities still remain one promising potential avenue for reform. Alternatively, if standardization of terms is too hard, I suggest that you could adopt a series of interpretive principles that would constrain interpreters when faced with ambiguities. Now, these could be imposed legislatively, or again, by industry groups seeking to self-regulate. They could also conceivably be imposed by state courts in some cases. The principles essentially are designed to force businesses into clear, harsh, brutal honesty statements of the realities of their privacy policies. So for instance, probably the most important principle is that any ambiguities in the policy should be interpreted against the drafter of the policies, and in the most kind of reasonable consumer protective manner. And again, that's not because I'm trying to impose a particular vision of consumer privacy. I'm relatively agnostic about a lot of data privacy practices. But the idea is to encourage clear statements when at all possible. Another principle is that broad privacy protective statements should not be easily torn to pieces by many exceptions that are contained in small print. And another one is that the design and presentation of each policy should be allowed to maximize, should not be allowed to minimize the ways in which policies can threaten consumers. So you can't essentially manipulate the design, the way you present the policy in order to deceive. And the article illustrates all these principles with examples from actual policies and the Ombuds reports. Again, the purpose of all these proposals is simply to try to encourage plainer and clearer statements of policies and to provide some guardrails against the sort of lax interpretive practices that might otherwise govern, particularly if the only accountability is from evaluators within companies in light of the very low likelihood of any regulatory action. These proposed solutions are, in other words, very much designed to take account of the structures within which interpretation is typically practiced in this narrow context. There aren't some sort of broad principles of interpretation. As a closing matter, I just want to acknowledge that many privacy experts don't like this sort of focus on privacy policies. They don't work, no one reads them, or it's a distraction from the substantive regulations that are the real hope of privacy regulation. I think that would be a response of many experts to this kind of work. I don't necessarily disagree on the merits with any of those observations, but we live in a world in which the notice and choice model of privacy regulation remains fairly prominent. And ignoring policies and their interpretations doesn't seem like the most responsible approach to me. Finally, also, I think I should note that some of my suggestions could in fact be ways of beginning to introduce more substantive regulations in a way that integrates with the notice and choice regime and reflects empirical studies on the actual policies that are communicated by the use of various terms in policies. Thank you for watching this video. If you're interested in seeing the details and examples, I hope you'll take a look at the actual paper, and I very much welcome any feedback that you might have. Thank you.